folks. I'm Richard Fulton. I'm a fellow for religious freedom at the Freedom Forum. Also, I have the honor of being one of the coordinators of this periodic Brown Bag Lunch series. And today we're going to be, first of all, this is the first in-person meeting of this group in 3 years?
More than 3 years.
3 years now. So it's a hybrid. We're here, several of us are in person. Several of you are listening in on Zoom. And it's a landmark day. So to deal with that, we actually have a landmark speaker, Bill Galston, who is a Brookings Institute Ezra K. Zilkha Chair in Governance Studies and Senior Fellow, and also Wall Street Journal columnist. And I'm sure I could say much more about his background and his credentials, but we want to get the program started. This program today has to do with what has become a very controversial and important issue in New York State, but of course with implications for the rest of the country. Let me first say that it has to do with an issue which I think is the marquee issue these days in church-state relations. We've been dealing for a long time with issues, Establishment Clause issues. What can the government pay for? What's it not allowed to pay for? That's shifting ground. But the real headlines, I think, these days have been in the question of when the government seeks to regulate, how far can it go? What can it demand of religious institutions and of religious believers in the face of their religious beliefs? At what point can they demand that things be done that these religious institutions or religious individuals believe are contrary to their religious beliefs? And in fact, the Supreme Court has heard argument, and we're awaiting decision in a particular one of such cases, Creative 303, which has to do with whether a webmaster can be compelled to, prepare a website in violation of religious beliefs about, in this case, same-sex marriage. So in that context, there has arisen in New York a huge controversy over the extent to which the state of New York can impose on religious schools requirements to provide secular studies, and that has to do with Hasidic schools in New York, which have been fighting against such regulations. There are issues. First of all, the government's authority to regulate generally, and then of course also to what extent does it make a difference when the government is to some extent subsidizing that education. So there's a lot to talk about, and we have here to guide us, as I said, Bill Galston, who has written what I thought was one of the more thoughtful columns as opposed to simply an advocacy column on the issues that are presented. So without further ado, I'd like to present it to Bill. Please take it away for us.
Well, thanks, Rich. It's a pleasure and an honor to be here with you at the first physical reconstitution of this long-running hit show. And thanks, Harvey, for receiving me. I have to say I'm having a bit of an Admiral Stockdale moment. For those of you who remember the late, great 1990s. What am I doing here? Because I'm neither a lawyer, nor a law professor. I've taken exactly 2 classes in constitutional law in my life, and they were, and only one of them was at the graduate level. So, why did I write the column? Why am I here? Well, I think it's fair to say, first of all, that throughout my career, both as a scholar and a politically engaged person, I've been an unfashionable defender of a very expansive view of religious free exercise. I defended the holding in the Yoder case from the day it was handed down, which was my last year of graduate school. As soon as the infamous Smith decision was handed down, I started writing analytical screeds against it. And then I was fortunate enough to enter the Clinton administration at the beginning in a fairly senior capacity. And I had the opportunity to represent the Domestic Policy Council in the little gang that got organized itself to get RFRA enacted into law. And then about 10 years ago, I was flabbergasted to receive the annual National Religious Freedom Award for my role in helping to enact REFRA. I got it from the Ethics and Public Policy, the Ethics and Policy, Public Policy Center. If you know anything about the center, you know it is a very conservative organization, not notably friendly to Democrats or liberals. And so for all those reasons, when I encountered the controversy that Rich introduced a couple of years ago, I was very surprised after working through the law and the facts to find myself more inclined to the position of the state of New York than I was the position of the Hasidic schools. And so I just want to take a few minutes to get the conversation started by trying to explain why I found myself in that position, although I was sympathetic emotionally, to the claims of the Hasidic schools, but as a legal and policy matter, I just could not get there. So first of all, I don't know what the Supreme Court is going to do with religious free exercise, jurisprudence in the next decade. Rich and I were talking, while we were outside, in the fire drill, and he noted correctly that this is a particular focus for this court. And it is certainly possible that we'd be having a different discussion a decade from now than we're having now. But right now, the following things are clear. First of all, and this has been black letter law since Gibbons v. Ogden, which will celebrate its 200th birthday next year, that there is a domain of state police powers where the states enjoy preeminent authority. And from the very beginning, control over education has been one of the core elements of state police powers. The federal government exercises control over education in two ways, principally. And for all I know, it's two ways only, but I'm not going to pretend to know that when I don't. First of all, if there are U.S. constitutional issues implicated, usually issues having to do with the Bill of Rights. And secondly, when the federal government imposes constitutionally appropriate conditions on the receipt of federal funds. And so a lot of the major education programs that we read about and which are handsomely funded in the annual appropriations process are not mandates on states. They are offers of funds with conditions attached, and those conditions have been deemed constitutionally appropriate. I mean, there's another discussion we could be having, about the conception of unconstitutional conditions. Suffice it to say that the education laws are on the right side of that line, wherever that line happens to be. So if the states have principal authority, and if they are the principal regulators of schools, public and non-public alike, as they are, then what are the bright lines that Supreme Court jurisprudence has established? Interestingly, most of those lines were drawn a century ago in the 1920s with three key cases. Let me just review them very briefly. One is the case of Pierce v. Society of Sisters. It was a state of Oregon case. I think it was 1925, sometime around there. And the issue was whether the state of Oregon could require all students of public school age to attend public schools only. In other words, render parochial school systems illegal. And the court said flatly, no, you can't do that. And interestingly, they didn't cite any particular constitutional clause in support of this. But the key passage of this case reads, the fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state, famous line. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. Now, to say that the child is not the mere creature of the state is not to say that the state has no authority over the child, but it is to say that there is a freestanding second source of authority over the child, and it has to do with the parental relationship or the guardian relationship or whoever stands in loco parentis in that relationship. So that much is clear. If the state of New York said, all the Hasidic students need to attend public schools, that would be on its face unconstitutional. So we can take that off. Now, here's the second key case, Myers v. Nebraska, which was handed down exactly 100 years ago. And that case stands for the proposition that states cannot forbid the teaching of or in languages other than English as part of the school curriculum. This issue arose because there was a lot of hostility to German language education stemming from the First World War, an enormous amount of anti-German prejudice during the war and afterwards, and the legislature and the governor of Nebraska responded to that prejudice by trying to outlaw all instruction in a modern language other than English. So you could study Latin, Greek, or Hebrew, but and they didn't care whether anybody studied Spanish, but they wanted to make damn sure that nobody would study German. And the court said, you can't do that. Right? You can't wipe out, you can't require instruction in no language other than English. And here's what the court said. And I think it's important for current purposes to attend to this language. The power of the state to compel attendance at some school, that is to say, compulsory education, and to make reasonable regulations for all schools, not just public schools, including a requirement that they shall give instructions in English, is not questioned. Nor has a challenge been made of the state's power to prescribe a curriculum for institutions which it supports. That is, to this day, black letter constitutional law. And so, and so if the state of New York were to tell the Hasidic schools, you must conduct all of your instruction in English, that would be on its face unconstitutional, consistent with the Myers doctrine. But it would not be unconstitutional or cross any other line to say that some of that instruction, for example, instruction in core subjects, has to be in English, and then alongside of that, there can be a Yiddish curriculum or Hebrew curriculum or whatever it is. The third case handed down in the 1980s, somewhat less well known, is the Farrington v. Tokushiga case, which originated in the state of Hawaii, which of course had a very large Japanese population. And there were many Japanese schools, Japanese language schools. And even at that point, fears were rising that the Japanese speakers could turn into something like a fifth column in Hawaii, should there ever be a conflict with Japan. And so the state of Hawaii came down hard on those schools and regulated them so heavily as to essentially wipe out the difference between the private Japanese language schools and the public schools. And the court said, no, you can't do that. Right? There's a line between regulation and total control. And if you regulate so much as to eliminate any significant difference between the private Japanese language schools and the public schools, you have crossed that line between regulation and takeover. And we're not going to allow you to do that. This brings us to Yoder. And given the fact that this case has become the modern touchstone, I think probably for a lot of, Rich, in the article that you were kind enough to send me, Yoder played a central role, not the only role, but the central role. And I think it's fair to say that, among lawyers, but also among political theorists, of whom I'm one, Yoder has become a real touchstone. And the fact that I defended it when most of my colleagues in my then profession, were attacking it already said something. So I think it's important to understand what Yoder stands for and what it does not stand for. I suspect, I think everybody else around the table is a lawyer who went to law school. I'm not sure about the people online, but I suspect very strongly that you're lawyers. And so even if you didn't look at the three cases I've just summarized, you probably were made familiar with Yoder. And the basic issue in Yoder was whether the Amish community in the state of Wisconsin had to comply with a state law that required formal education until the age of 16. The Amish said, no, we are perfectly happy to go along with required formal education until the end of 8th grade, which is usually around the age of 14. But those years after 14 are very important years, for the, so to speak, early adult training, in the principles and practice of our faith and our community. And to require us to undergo formal education at that point is a bridge too far, that it infringes on fundamental free exercise claims. And also, to go back to the Pierce language, the fundamental theory of liberty on which all of our institutions, governmental institutions, repose. So Yoder stands in the first place for the principle that religious liberty, although a very powerful claim, is not absolute, but needs to be balanced against compelling state interests. And including, the court said, preparing students to participate in the economy and carry out their duties as citizens. Now, the Amish community, in standing up, against that, accepted those state interests as compelling. They did not say that the state of Wisconsin or any other governmental entity doesn't have the right to pursue those interests and to mandate certain behavior in pursuit of those interests. It simply said that the state, in requiring education up to the age of 16, was exceeding the means needed to achieve those compelling state interests. To use the legal language, the requirement was not narrowly tailored to, and was not necessary to fulfill the valid state aims. And the third thing that Yoder stands for is the holding that, as a matter of both law and fact, that the state of Wisconsin did not discharge its burden to show that terminating education before the age of 16 would undermine its pursuit of its legitimate and compelling interests having to do with the preparation of students for the economy and also the duties of citizenship. So at the end of 8th grade, the state of Wisconsin said, this was 50 years ago, mind you, 51 to be precise, that that if you came away from 8 years of formal education as a competent English speaker and in mastery of the basics having to do with reading, writing, mathematics, science, etc., that was enough to meet the education, to meet the economic purposes and the civic purposes of education, public or non-public. So with those 4 cases, I think we have, I'm setting aside a bunch of, Establishment Clause cases having to do with public funds for textbooks, for maps, you name it. I mean, the court danced on the head of a number of sharp pins, during much of this period to distinguish real Establishment Clause issues from not so. Okay. This brings us finally to the topic. My argument is that New York State's regulation of Hasidic schools is on all fours with the lines drawn by the Supreme Court in the 4 cases that I've just summarized. Okay, and so if the state of New York erred, it was not a constitutional error, as the court now defines constitutional error. So that's contention. That's contention number 1. So that then raises a couple of additional questions. First of all, is the state of New York, in particular the State Board of Education, exceeding the legal authority that the state of New York has granted it? I'll return to that issue. And secondly, as a matter of fact, have the Hasidic schools behaved in such a manner, as to violate laws concerning the regulation, concerning the direction and regulation of the public schools that the state of New York has the right to enact? Now, some of you may have heard that there was a case handed down just a couple of months ago. I think it was March of this year by a New York State judge that limited the power of the state of New York to enforce the regulations that it had created in September of last year after more than 5 years of back and forth, hundreds of public hearings, 2 false starts, a draft, a draft regulation promulgated notice comment. It got 350,000 comments, which must be some sort of state of New York record, maybe a record for any proposed regulation. Okay, the New York State School Board then adopted those regulations, which clarified requirements that all schools, public and non-public, including Hasidic schools, had to obey. The case handed down in March of this year did the following. It upheld the state's right to prescribe a core curriculum for all schools, including non-public schools, and to require the teaching of this curriculum in English by competent teachers. Now, each one of these adjectives, has a lot of law and regulation behind it. How do you determine who is a competent teacher? Don't get me started, okay? That's a rabbit hole that we'll go down. Not even the Mad Hatter could get us out of it. But let's just take that as something ascertainable according to law and regulation by the state of New York. Furthermore, this court upheld the requirement that instructions in core curriculums in non-public schools must be, and I quote, substantially equivalent to that of public schools within the city or district. And the court dismissed all of the yeshiva's constitutional challenges. It dismissed all of the yeshiva's procedural objections to the new regulations. The yeshivas argued, and I'm not caricaturing this, that, well, the Board of Education of the state of New York had received 350,000 comments on the draft regulations and hadn't made any substantive changes in those regulations, and therefore the procedure was per se illegitimate. As you can imagine, the court had it made its fast work of that argument. Furthermore, the court upheld the substantial equivalency criterion as applied to the yeshivas. Bang, bang, bang. So what did the court do? It's being celebrated as a big victory in some quarters. It said that the Board of the State of New York had exceeded the authority given to it by the State of New York to use certain enforcement mechanisms. There are some things that the board could do, but some things it couldn't do, in pursuit of those three objectives that I just listed, which the court validated as legitimate. Okay, so with that as the state legal background, let's now go to phase 3, which I'll call factual issues. Now, obviously, I'm in no position to serve as a finder of fact. I don't live in the state of New York. I'm not a close student of Hasidic schools, etc. So all I can do is read the record and come up with a list of facts that are not contested. It's the best I can do at this point. Okay, what are these facts? First of all, we are talking about Hasidic schools, not modern Orthodox schools. And most of these Hasidic schools, not all of them, are run by the Satmar Hasids. Okay? And they're a pretty tough group. They have built or they've tried to build a wall of separation, to invent a phrase, between their community and the outside world. They've been pretty successful. And the question raised by this controversy, one question raised by this controversy is, at what cost? At what cost? And is that cost something that the state of New York is required to bear or required to allow students at these schools to bear? Okay, so here are some factual issues that I will confess influenced my judgment. They may have different impacts on other people. But in 2019, one of these Satmar schools, it's the Central Talmudical Academy, agreed to administer standardized state achievement tests in math and English to more than 1,000 of its students. Not a single one of its students passed these tests. Not one. Fact number 2, in that year, 2019, it's the last year for which these statistics were available before COVID came in and just, obliterated everything. In that year, 2019, only 9 schools in the entire state had fewer than 1% of their students testing below grade level. Each and every one of these 9 schools was an Hasidic boys' school. Each one. Now, one argument made by the defender of these schools is that, well, this isn't a fair comparison because these communities are significantly poorer than many other communities. Now, there's an interesting tension between that argument and another tension, the leaders of this community also make, but I'm not going to go down that road either. And that in addition, most of the students were not native English speakers. So the valid comparison is to low SES schools and or schools filled with mostly non-native English speakers. Now, let me set aside the fact, which is uncontested, that many of these non-native English speakers had been here, their families have been here for 3 generations. That itself tells you something. And what it tells me is not so great. But when you do the comparison between low SES schools and the performance of the Hasidic schools or not schools with majority non-English speakers, non-native English speakers, and comparable Hasidic schools, the performance of those 2 categories in public schools is much, much higher. Not great, but much higher than with the Hasidic schools that allowed standardized tests to be administered to their students. Why would they allow that, you may ask? Well, there are some forms of public aid, the receipt of which is contingent on this kind of testing for regular basis. Otherwise, believe me, they wouldn't have done it. Okay, fact number 4. Unlike the Amish, unlike Catholic parochial schools, the leaders of the Hasidic community simply reject the authority of all public education laws. And in support of that proposition, let me read a remark by Satmar leader Aaron Teitelbaum, one of the 2 key leaders of that community, as I understand it. I think, but Rich can correct me, one of 2 warring brothers, who between them divided their father's domain, but have not agreed on much since then. Okay, here's what Aaron Teitelbaum had to say. And this is really, I think, there's, Michael Kinsley, wants to find a gaffe, as an occasion on which a public leader, accidentally tells the truth. Well, by that standard, this is a classic gaffe. He said, the truth is we either had very little secular studies or none at all. By the way, that truth is entirely consistent with the factual record as I've been able to discern it. He went on to say, we will not comply with the state's requirements and we will not follow the state education commissioner under any circumstances, period, full stop. In other words, we are our own law. We don't have to follow yours. We do not recognize the authority of public law. Now, why do I think that position articulated by Rabbi Teitelbaum is dead wrong from every conceivable standpoint? Well, point 1, these students and their families are not resident aliens, right? If we had a category in US law of permanent resident alien passed down from generation to generation, then we'd be having a somewhat different discussion. But unlike some countries, like Germany until very recently, we do not have such a legal category. If you're born in the United States, you're a citizen of the United States, period, full stop, with very, very few and very highly technical exceptions. These students and their families then are not resident aliens. They are citizens. They vote. And they are eligible to receive public funds for their schools, among other things, which they do at very high levels. Some of the numbers of aid to these schools in particular on an annual basis are startlingly large. And this raises the question, is citizenship a one-way street, or does it come with certain responsibilities, such as learning English and the basic skills needed to function as citizens and as productive members of society? And I phrase that question rhetorically because I think the answer to that question is very clear as a matter of theory, as a matter of morality, as a matter of regular practice and expectation. Second, let's put these facts up against Yoder. Yoder stands for the proposition, among others, that education that students receive cannot be so limited as to make it impossible for members of the community to leave if they so choose and to be able to function in the non-Amish community or the non-Hasidic community or what have you. Now, this obviously is a direct clash with a community that wants to make exit impossible. But it is a fixed principle of our constitutional systems that religious groups and voluntary associations are not prisons. And they are not allowed as a matter of law to disable their members from leaving if they choose and to be able to function in a in a world other than the world defined by the boundaries of that community. These communities, including religious communities, cannot be prisons. They cannot be designed to make it impossible for people to function outside them. Third, Rabbi Teitelbaum, as a matter of constitutional law, is on, I won't even say thin ice, because that suggests that he has some ice to stand on. He does not. Okay. As we've seen from the cases I've reviewed and many others I haven't, the rights to control the extent and the content of public education are not the sole property of the parents any more than they are the sole property of the state, right? It is a division of authority. So the desire of parents in their communities should be taken into account, but they are not always dispositive. They can't be. Now, obviously, this has been a matter of considerable controversy, in various quarters, including the adjoining state of Virginia in the past 2 years. And, and any candidate for political office who is stupid enough to say that the parents ought to butt out and leave it to the state to make these decisions is going to get his head handed to him, as Terry McAuliffe did. But to say that the parents have some rights, which they do, is not to say that those rights are plenipotentiary, which they are not. They aren't. Okay, so, in conclusion, let me put into evidence, as exhibit something or other. I haven't lettered them or numbered them, but a letter from Avraham Weinstock, who is an official, of Agudat Israel of America. This letter was published just last month in the Wall Street Journal. And here's how he defended the schools that his organization is in the business of defending, and it's a legitimate business as far as. Number one, he said, parents ought to decide how and where their children should be educated, asked and answered. They have a role in that. They certainly have a role in deciding where, but they do not have complete authority to decide how. That's a critical distinction. They can send their children to non-public schools. They can homeschool them according to the state of New York and every other state in the union. Best of my knowledge, I don't think a single state forbids homeschooling, and they wouldn't dare forbid non-public schools because they're tossed out immediately. So, If that is the principle on which he's basing his defense of the schools, it's wrong on its face. Next, he said, parents send their children to private schools precisely because they want something substantially different, not substantially equivalent to what they could obtain for free from public schools. Within limits, they have the right to something substantially different. But the limits of that difference are clear, right? The state of New York has the right to establish a core curriculum and to insist that the language of instruction of that curriculum be English. There's no legal doubt about that whatsoever. Third, he said, if public schools are rigidly controlled by the government, that would leave no independent classroom in which to educate one's child. Well, as we know, the third of the four cases that I reviewed, the Farrington, Hawaii case, does stand for that proposition. If the control is so rigid that there's no choice whatsoever, that there's no difference between the private school and the public school, and the state enforces that non-difference, that goes too far. But that is not what the state of New York is trying to do. It is not trying to say that there can't be a Yiddish curriculum or a Hebrew curriculum, or the language of instruction can't be either of those. It says simply part of the day needs to be devoted to secular subjects taught in English. Finally, he said, we are proud of the thriving Orthodox Jewish communities in New York and the values they hold. They have maintained Jewish continuity in a way others have not. I think that's true. And the question is, does maintaining Jewish continuity, as the Satmars define it, trump any and all state interests? I think we already know the answer to that question. It's no. Right? So if that is the best if that's the best argument that someone who leads the division of Agudat Israel devoted to public advocacy, I assume that all the other arguments are even weaker. Okay, final point. Could the state of New York decide simply, to accommodate by selective non-enforcement of its laws? I suppose it could. I'm not a lawyer, but I suspect that some people on the other side of that would, raise legal objections pretty quickly. And it's not clear to me which way the courts could do. Clearly, the fact that a state has the right to do something doesn't mean that it must do that in all cases, or that doing that thing is the right thing to do in all cases. But if the question is, as a matter of law, is the state of New York exceeding its authority? My answer to that question is a flat no. If you're asking me as a matter of policy, whether it is right to allow successive generations of members of the community who have lived in the United States for generations, not even to acquire basic competency in English, where English is not only the language of commerce, but also the language of civic disputation. It's a matter of policy. I think that's a mistake. But why don't I stop there, and we can now proceed to discussion and Q&A.
Thanks very much, Bill, for a really wonderful survey of the background, the legal background, and also of the situation in New York and your views on it. So I want to begin the conversation by, first of all, turning to Yoder, and I want to throw out for discussion my perspective on what the case means for all of this.
Mhm.
You may recall I was quoted in the Washington Post saying that Yoder is sort of a template through which we have to look at this case. And I think you rightly responded in your op-ed, in which you kindly made a very kind reference to me, first of all. But second of all, I think you were right to point out that the fact that Yoder is relevant doesn't mean it's dispositive. But that was, of course, not what I actually told the Washington Post reporter. Journalism being what it is, I mean, it's not a bad thing, but they pick out the quote. They pick out a quote, and you have no control over the fact that they don't happen to mention the other things you said.
Right.
But I think the article that I wrote demonstrates my perspective that this is, in fact, it's a relevant but not dispositive case. But I do one of the ways in which it's relevant, beyond just clarifying the nature of the state's interest in education, is that I think that the case makes clear that, in fact, it's not just simply, not all cases are equal, obviously. And Chief Justice Warren Burger, in upholding the right of those Amish communities to not have their children go to school beyond a certain grade, made the point that old order Amish communities today are characterized by a fundamental belief that salvation requires life in a church community separate and apart from the world and worldly influence. This concept of life aloof from the world and its values is central to their faith. In other words, in Chief Justice Burger's opinion for the majority, he is saying that is a relevant fact in determining, it's not something that takes place in a vacuum, it is relevant to determining what the rules are that the state can legitimately impose on a religious community, that it is an insular separatist community, and they're raising their children, not to say they can't, perhaps they can't make a prison of those for their children, but they are entitled to raise their children with that worldview that they ought to be separatist. Some of those children will continue to live in that world. Others, as we know from the Hasidic communities in Brooklyn, there are a number who leave. They leave the community. It's not, they decide it's not the life for them. But there is a legitimacy to that, and it's a factor that the courts need to take into account in determining what they can impose on the schools. So for instance, we know that where the Hasidic schools, like they don't not keep their kids at school beyond 8th grade, but they could apparently on the president of Yoder, they could decide we're going to keep the kids out of school after a certain grade. But the other thing that they may be entitled to do, and that's not what Yoder is about, is have somewhat of a different curriculum. In other words, the state may be entitled to say you have to have education that meets a certain standard, but that may not necessarily be the same standard for everyone. That is to say, there may be a ceiling as to what the state can insist upon in terms of what is provided. And it may not be the same for these separatist communities as it is for, say, Catholic schools, or for that matter, other Jewish schools. And so I think one has to, that makes the determination as to where the limitations of the state's authority lie more difficult, because we're taking into account the fact that these are separatist communities that have that because of the nature of separatist communities have different interests. But I think it's something that the courts need to take into account in determining to what extent they can impose standards on those schools. So that's my theory, and I'm interested to see what you have to say about it.
I mean, I have no problem with that as a very general proposition. But but Yoder was not simply decided on the basis of that kind of general proposition. The facts before the court also mattered. And the fact that the Amish community, conceded the legitimacy of the state's definition of a core curriculum for grades 1 through 8 was a very important fact, because that helped the court decide that that the Amish schools, in complying with those core requirements, did not deny the validity of the state's economic and civic interests in prescribing a core curriculum. And one of the fundamental differences between the Amish and the Satmars is that the Satmars deny what the Amish affirm. Okay, and I think that's a distinction. That's a distinction with a big difference. Although this is not an issue before the court, at least I don't think. But I'm going to go on to make a second point. Not only do the Amish not make their community a prison, but as you know, they have an institution called Rumspringa, which means that kids at the age of 18 are urged, and in some cases ordered, to go outside the community and to spend 2 years outside the community. That's a maximum. They can spend less if they want, but it's as much as 2 years. And then if they return, having had that experience of the outside world, to make a life commitment to the Amish community. And it's been a while since I've read the statistics, but many Amish young people at that point decide that no, the life inside the community is not for them. And so, and as consistent with a Protestant conception of what religious faith involves and its voluntary nature, it is that adult recommitment to the community whose norms and principles they imbibed, as children, that makes the difference. I think that is exactly the reverse of what the Satmars do, right? And I can understand why they don't. But the fact that they have no such institution and indeed would fight tooth and nail against any effort to expose their kids to the quote unquote temptations of the outside world is something I have to say that influences my judgment, as a liberal, philosophical liberal with an expansive definition of legitimate I've defended the principles of maximum feasible diversity and maximum feasible accommodation. But there's a line between maximum feasible and accommodating everything just because someone says this is what I believe and this is what I want, that shouldn't be crossed. And I think Aram Teitelbaum and people who believe what he believes have crossed that line.
Those are all good points. I would only say, I'm not sure disagreement, but just to expand on the point I made, Pierce Against Society of Sisters, which I believe is the Pierce Against Society of Sisters of the Society of Sisters of Jesus and Mary, something to that effect.
They ran Catholic schools.
They were Catholic schools. It also happened to have been the first case in which the American Jewish Committee, my old employer, ever filed an amicus brief. May have been the first amicus brief by any Jewish organization. Leading to the question of what's a nice Jewish organization doing filing a brief in a case like this. But it was because of these important principles of, on the one hand, preserving the ability of let me just finish the point I'm making and then we'll turn to you. So that case also, in addition to standing for the proposition that parents get to decide where to send their kids to school, also says explicitly, of course, the state has the right to set standards. But that doesn't resolve the issue of which standards. That is to say, it may be the case that one has the right to teach, that they have a right to impose a basic understanding of math and science and English, but there comes a point where just because the state says something is core curriculum or to be core curriculum, that in fact there isn't a limit beyond the state can't go in terms, constitutionally go, in imposing that vision on schools. And that's the question. I'm sure courts and lawyers will address those issues one of these days. But I'm just saying that we have to be careful. Rabbi Ari Lam of the very renowned Lam rabbinic family, who supports the idea of there being basic standards, points to a case in which the New York State report criticized a certain school because they wouldn't allow the teacher to discuss politics with his students, quote unquote, discuss politics. And, he brings that out as somehow that they view that as a damning fact, somehow brings out the question of whether the state can't overreach in trying to impose standards on religious schools. And to my mind, that clearly there has to be There has to be some kind of a limit, even though the school's authority in general to impose standards really can't be denied under any of the existing law. So that was just by way of response. Sir.
I too want to thank you for your excellent and enlightening presentation. I appreciate it. I also want to thank you for your excellent and enlightening presentation. It was superb. I think.
Can you press the button here so people can hear your question?
This?
Yeah.
Okay, sorry about that. I think what we're on the question of whether New York State can selectively force, as you alluded to at the end, I think what we're all avoiding is where the legal process meets the political realities. And as you're aware, the Satmar community of Kairos Joel in Orange County, my home county, has a population of an exponentially growing population of over 40,000. Add that to those in Brooklyn and Williamsburg, and tack on the Lubavitches, Crown Heights, there's significant numbers now. And many New York State senators, members of the Assembly, and congressmen are beholden to this community. And as a result, policy is dictated accordingly. So can New York State suppress enforcement? We certainly hope we don't.
I'm not going to argue with your facts, which are correct. I just add that, and I don't mean this pejoratively, although I do have some doubts with the factors that lead to it. This is one of the few block votes. It's one of the few real political machines left in New York State, right? In many other communities, they incline so they're 60-40, 70-30, 80-20. But in many of the districts, which are almost predominantly or entirely populated by people in one of these communities, they cast votes in accordance with the leadership and determination of rabbinical authorities. That's simply a fact. And so they are because elected officials, if they receive the support of those leaders, can count on virtually every vote of those communities. It can be a decisive block in the way that very few other ethnic groups in New York or anywhere else can be. Now, what you say is interesting because many Satmar leaders argue that the shoe is really on the other foot and selective enforcement is being applied to them. And I don't think that's a very compelling argument, though I don't blame them for trotting it out.
Well, yeah, I had one question. It really was a follow-up on one of the questions that Richard had asked.
Yeah.
And this is really more about what might happen in the future. Your description of Yoder, I think a lot of people would agree with, but the court has shown a lot of more sensitivity to establishment principles or free exercise than establishment principles. And just as they found that the Heller case, which said you had a right to carry a gun in to protect yourself in the home, was expanded last year to say now you have a right to carry a gun outside the home. You think the court is likely to seize on the sentence that Richard mentioned to reinterpret Yoder to give more accommodation for a community's right to preserve itself, even if it borders on becoming a prison?
I'm going to defer to Rich on that question because I don't follow the court with the care and precision that he does. And based on our private computation, it sounds to me as though you regard that as a real possibility.
I think that I think the what we were discussing earlier off cameras where was the change in the court vis-a-vis the handling of the conflict between regulation of public health and religious liberty issues of the court. even in the course of 1 year, having shifted grounds on the issue of whether or not regulating capacity at a house of worship was legitimate in the face of a religious freedom objection. So, and it may well be we're going to see a similar change when it comes to vaccinations. So, while I would hope that the court would continue to stand for the proposition that standards can be imposed, and especially when you now, we may disagree on what those standards can be, but that there ought to be standards. And with the door now having been opened to increased public funds going to religious schools, the question of what kind of regulation there should be, whether or not, in the phrase of the late Dean Kelly, whether the king comes with the king's shilling, we don't know. We don't know, but it's quite possible that religious schools will be given more leeway than even many of those who are concerned about protecting religious freedom would like, as the court moves along. But we don't know. We've yet to see. I had another point I wanted. Yes.
I don't know if we have any questions from. I don't know if Vicky's still on the line, or if we have any questions from those who are online. Maybe close that.
Anything? No, I think. Let's see. Someone.
Oh, yeah.
Vicky is testifying. So she had to step away from her computer. She's testifying at the DC Council, so I am covering for her. And I will tell you that there are no questions in the chat. There was a comment that just noting that the Amish have a Christian background, which is consistent with the larger American citizenship, and Satmars do not have that, of course, and that does have bearing on the situation. So that was the only comment. No questions, but please do feel free to put comments in the chat. It can sometimes be a little bit challenging toggling back between those who are in person and those who are hybrid. So Harvey, thanks for checking in to make sure that there were no questions in the chat.
Okay, so I have another area that I want to raise, and that is, first of all, it's very interesting to note that when the Times ran its series, it's well known, some would say infamous series on I think there are 15 articles by now that have been written on the Hasidic schools, that one could read a lot of that material and never know that there are Orthodox schools other than Hasidic schools, for instance, the so-called Litvish schools, Mitnagdic schools, whatever phrase you want to use, to say non-Hasidic Haredi schools, which in fact do a much better job of providing a secular education. And that, as far as I know, nobody has raised the question as to whether or not they're doing an adequate job under the laws. Maybe somebody somewhere, I'm sure, has said it, but it's not. They're not being challenged that way. To say nothing of modern Orthodox schools, which are really excellent in terms of Solomon Schechter or conservative schools, or many other kinds of Jewish schools. So, but the particular focus, the particular focus of the Times on these as quote unquote Orthodox schools raises a question not about the merits of the facts in all respects, but really as to whether there's not an attitude. It's really a political question more than a legal question, whether we ought to be aware of some hostility in the society towards people that insist on adhering to a particular way of life that's not the way of life of the rest of us, and which has led, in fact, the rest of the Haredi community and as well the Orthodox Union, which represents modern Orthodoxy, to come out and attack the increase in regulation, even though the schools that they are associated with or responsible for, in fact, don't have a problem, would not have a problem under these standards. And the question is, why are they reacting this way? And I think it's in part because they're reacting to the hostility they see, and also a fear of a slippery slope in which ultimately the state comes in and starts telling them how to run their schools in a way that would be contrary to the way of life and their view of the world, which even though they provide a good education is for sure different than received wisdom in much of the rest of society. So I wanted to ask you to reflect on these sort of societal questions and how they're playing out.
Richard, can I just piggyback on that just before you answer that? What about also the issue of the enforcement of if the court were to rule in a particular way? could the court really enforce things in the way that you're?
Well, that's the question placed by that, New York State Supreme Court. Of course, the New York State Supreme Court is a tri-level court. But by that Supreme Court judge. But that seems to be going off on a question of New York law, very specifically of New York law. That is
Not federal, but
yeah. So the question is, that will be an issue. Right now, the schools have prevailed, although they may not see that way. The schools have prevailed at the trial level on a state law question. That's not to say that court may be reversed. Some kind of federal challenge may be made in some way, although education is by and large a state law question. So there are all kinds of ways in which it could still come up, and it's really up to the imagination of lawyers to figure out how to do that.
Yeah, as I indicated in my opening remarks, the schools prevailed on one of the 4 points that they were urging. It's not a trivial point because it has to do with the power of the New York State Board of Education to enforce the standards that it establishes. And there's no question about the fact that the court has substantially restricted the enforcement powers. That's the point. That's the only point where the schools won. But at the practical level, it could turn out to be very important, even though the schools wanted the court to go much further in denying the legitimacy of the kind of regulation that the state of New York is in the regular business of doing. As to the motivation of the New York Times, I can't speak to that, right? I do know this, that there is a reason that when you take an oath in a court of law and before the Congress of the United States, before you testify, if you're giving testimony under oath, there's a reason why you say that you swear to tell not just the truth, but the whole truth. And telling part of the truth is not telling the truth. And to the extent that the New York Times deliberately set out to convey the impression that it was speaking about Jewish parochial schools in general, as opposed to these schools in particular, well, we sent our son to the Charles E. Smith School, and there's no question about the fact that he came out with a first-rate 2-track education. I mean, there is no contradiction between between teaching students how to achieve at a very high level in the courses that are required of any certified school in the state of Maryland or probably anywhere else on the one hand, and getting a good education in rabbinics, in Talmud, et cetera. Obviously, you don't get the kind of education in Talmud that you would get in a school that is entirely devoted to the study of the Talmud. But and when I read the articles in the New York Times, I read them all. I don't have any kind of shock of recognition that somehow they're talking about the school that we chose to send our son to. There's just no comparison. It was absolutely clear to me that it was apples and oranges. Now, whether it would be equally clear to all readers, whether the Times and a concluding article should have framed the preceding articles about these schools in a broader account of Jewish educational institutions for K-12, that wouldn't have been a bad idea. Do I think that these articles are on their face anti-Semitic and bespeak hostility to the Jewish community in general? No. Is it possible that some of the reporters may have been morally outraged by what they saw as the very basic deficiencies of these schools? I can't rule that out. I can't rule it in. In other words, I just don't know. Right? I just don't know. And obviously, eternal vigilance is the price of liberty and indeed survival for Jews. And learned that lesson the hard way. And, I don't blame the defenders of the faith for reacting this way, but I just, I don't have a view on it.
Yeah, I think one of the contexts for this is the same community that feels like when they're attacked on the streets of Brooklyn, because they're identifiably Jewish people walking down the streets, and then they're physically attacked in the Times, and others don't give that terribly much attention. That's also part of this environment in which those kinds of suspicions.
I can't argue.
Yeah.
Let me just ask a quick question because I'm not familiar with the New York State ruling itself. Did the limitation on the court say the Board of Education had no ability to enforce any of the standards, or was it more limited?
No, it was much more limited than that.
Okay.
It was a limitation of remedy for violation
Right.
of standards. And so one of the questions was, can the New York State Board of Education shut down schools that don't comply with the standard? The answer to that question is no.
Okay.
Second question, can the state board force parents to send their kids only to schools that meet these standards? Again, no. That was the gravamen of the New York State case, and those were significant limitations on the enforcement power of the school board. But they didn't reach any of the other powers.
I have one question. I know we're going to have to wrap up pretty soon, but
We started late, so we can go until say 1:45 or something like that.
So historically, how have the politics played out in communities where you had legislation that reflected religious or ethnic animus, like toward the Germans you mentioned, or toward a particular religious community? How do those things sort themselves over time politically?
Well, there's a problem, and it's a problem that goes to the heart of the role of courts in a system such as ours. The state of Nebraska, right after the First World War, was suffused with anti-German animus. I mean, it was a strong majority. Similarly, the state of Oregon, which is one of the strongholds of the Klan, was suffused with anti-Catholic animus. And I suppose that over time, these things might have sorted themselves out in the ordinary political process, but it wasn't clear how long that was going to take. And in the meantime, the potential harm to the German schools in Nebraska or the Catholic schools in Oregon, they were going to be put out of business, right? So, it seems to me that's the sort of situation in which damages are being imposed that the political system will either not solve quickly or maybe not solve at all. And insofar as those damages, constitutional damages, I would say that the courts did the right thing. We've seen what happened in the case of school segregation, for all those years when the court didn't step in. I know this is a very traditional and somewhat old-fashioned view. It's Caroline Products, footnote 4 view, but I don't think it's invalid just because it's old-fashioned. I mean, I think it's one of the core legitimate functions of the courts in a constitutional democracy as opposed to a majoritarian democracy. Now that raises some very interesting questions about the country that Miriam and I are about to fly off to next month, which is exactly the issue on the table. What do you want the courts to be? What's their role?
Yeah.
Obviously, it's right.
Well, let me just say the reference to footnote 4. I mean, the article I wrote very much. Footnote 4 it's I would say it's the most famous footnote probably in legal history. And
I don't know. Have you seen the Israeli film, The Footnote?
the footnote? No, I haven't. So basically, what footnote 4 says is that the courts have a responsibility to ensure that it's that there be protections afforded to discrete and insular minorities who are disadvantaged by lack of access to normal political processes, and that therefore there should be a stricter standard of review that impacts those particular groups. And I reference that in this article, which is about the intersection of interests of separatist communities in the larger society, and suggesting that footnote 4 is exactly what we ought to be thinking about. And even though it's true, as you've said, that this is not a community that is without political resources, so because the community of Brooklyn, but nevertheless, from the point of view of the larger society, they are certainly a discrete and insular minority. And we have to be, that doesn't mean they're right on everything, but it means we need to be very careful just in terms of our concern about having a constitutional system that cares for the rights of minorities, that we be careful where we tread. And that when we regulate in this area, that it would be aware of that impact, even though that doesn't say that at the end of the day, these educational standards shouldn't be enforced, but it does say we have to be thoughtful about
But didn't
about the
Justice
impact
Stone
on
use
these
that
minorities.
as a reason for imposing strict scrutiny? I don't, it's been a long time since I read that
Yeah.
case. So strict scrutiny, that methodological approach
Yeah.
takes care of exactly.
Yeah,
the issue
exactly
that
right.
you've raised.
In fact, right. I mean, it really was, just as a matter of legal history, it's very interesting how the court had that footnote. And then today we have these multiple standards, which are really grow out of that footnote, hence, which is why it's such a famous footnote. We really are good at getting towards the end. Any other questions or comments people want to ask? Yes, I see a hand. There is a hand up there on the screen. Yeah.
Hi, it's Rhonda Lees. I
Oh,
listened
Rhonda.
to most of it, so if what I'm about to say is duplicative, I apologize. There is a rabbi that I knew from camp, obviously it's a while ago, who has something called Martini Judaism, and he is Reform, very open. He had an article about this, and he talked about it simply from the perspective of forget everything else. It looks like some of our Jews are not being educated. And I should know better than to look at the comment section of any article ever. But the venom that came out was really fairly striking. And it's quite relevant to what we're talking about, because it was both people who said, I'm Hasidic, I'm in New York, I want to, don't tell us what to do, you're infringing on my First Amendment rights. And other people who said, do we really want people coming out of high school who, can't add up? But again, I just want to mention that it was the level of discourse that was so beyond something that we should be talking about. It was troubling. It was so consistent with what you're saying here. It's brought up good issues, but there was a lot of venom. I think it's the only way of describing it. And I'm not sure if there's a solution for it.
It's on both sides. It's incredible.
Very much so. Wait.
Bill, do you have any concluding remarks you want to share
No,
with us?
except to say that venom on both sides is a passably accurate description of American politics and society as a whole. So why should we be different?
Right, that's right. We're not exempt. Okay.
I guess that's it.
I guess that's it.
Thanks so much.
Come on.
You wanna-